Rock, this is file number 256930. The record reflects Mr. Rock's present here in the courtroom today. But we have counsel for your appearances on.
And a broker appearing on behalf of the people.
Thank you, Honor. Registration appearing on behalf of Mr. Rock.
This is set for a status conference today. Mr. Trush, can you tell me where we're at with this file?
Yes, Your Honor. I do believe that we have a deal that we're going to enter into today. And I apologize that we were a little bit tardy getting back to the court here. Mr. LaRock, we had some issues to work through in regards to community corrections. So I wanted to make sure we had that squared up to correct that issue and address it. But we do have an agreement that we intend to enter into today whereby he will be pleading to an added count 2. That would be possession of a narcotic less than 50 grams, I believe. And that is the 4-year offense.
Okay.
It's less than 25 grams. That's correct.
I had a 50% chance of getting it right.
Okay. And are we taking the factual basis to the methamphetamine?
Yes, and I will assist with the factual basis the court will allow.
Okay. Ms. Brucker, is that a correct statement of the plea offer?
Yes, Your Honor.
Mr. LaRock, have you had an adequate opportunity to speak with Mr. Trush about this plea agreement?
Yes.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. Mr. LaRock, are you currently on any kind of probation or parole?
Not that I know of. You know,
You would know. If you were on probation
Yeah.
somewhere, you would know. So you're not on probation.
Oh, okay.
He did indicate to me, I think he has a ticket that he picked up in another county.
Oh,
So
Yeah,
I
that
think
was
that's
before this, though.
you're not aware of any other.
I'm not aware of any other probation out there.
All right. So Mr. LaRock, what that means is that by pleading guilty to this charge of possession of a narcotic, the maximum possible penalty you can face would be up to 4 years and or a $5,000 fine. Do you understand that?
Yes.
Okay. With that penalty in mind, what is your plea to that charge today?
He's guilty.
Do you have questions for Mr. Trush about that? Or
I just want to make sure I just go along with what we talked about.
Well, if you want to take advantage of the deal.
Yeah.
okay.
I'm taking.
All right. So you're going to plead guilty today.
Yes.
Okay. I'm going to go through all of your rights with you. Okay. So right now you have the right to have a trial. You have the right to have a jury trial. You have the right to have the prosecutor prove beyond a reasonable doubt that you're guilty. You have the right to have any witnesses against you appear at a trial and to have them testify at that trial. You have the right to have any witnesses on your behalf appear at a trial. You have the right to be presumed innocent at that trial. You have the right to testify yourself if you wanted at that trial. And you also have the right to remain silent and to not have that silence used against you at that trial. Do you understand all of those rights?
Yeah, kind of, as much as I can.
Do you have any questions about all of those rights?
No, I'd have to study. I'm sorry.
Sure, that's all right.
Not used to this.
That's okay. That's why I want to make sure that you understand everything that's happening today, because it's important that you know exactly what's going on, because it all affects your rights in your life. So if you do have any questions, I want you to feel free to stop me at any time and say, hey, I'm not sure. Can you explain this more?
I appreciate that, but I'm pretty not think of any.
Okay, all right. So the other thing that's important with regard to all those rights is that you know that by pleading guilty, you're going to be giving up all of those rights. You don't have any of them anymore.
Yeah, I understand that.
Oh. Also, if you wanted to appeal this plea that you're making here today, in other words, if you wanted to try and get it reversed later, you would have to ask for the next higher court up, which is called the Court of Appeals. You'd have to ask for them to hear your case, and they could say no, and then that would be it. You'd be stuck with what happened here today. Do you
Okay.
understand that?
Yes,
Has anybody threatened you with anything to get you to plead guilty?
no,
Has anybody promised you anything other than what we've talked about here in court today?
no,
Is it your own free choice to enter this plea today?
yes,
Are you pleading guilty to this charge because you are actually guilty?
yes,
Okay, Mr. Trush, if you'd like to, Mr. Trush is going to ask you some questions about what happened.
So,
Thank you.
Mr. LaRock, on October 20th of 2025, were you hearing on Seagull County?
yes,
And on that date, was there a pipe inside your vehicle?
yes,
And on that date, did you know that there was methamphetamine residue in the pipe?
I thought it was,
But
you know, I thought it was just,
now today, though, do you know that there was residue inside that pipe?
yes,
And do you have any reason to dispute the test that it was methamphetamine?
no,
And you have no lawful authority to possess methamphetamine?
no,
I think there's a factual basis.
Mr. Rupert?
I agree, Your Honor.
Okay. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Your Honor.
Yeah, sure.
Okay, Mr. LaRock, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing in about a month. You'll be given notice of the date and time of that hearing. It's important that you stay in touch with Mr. Trush between now and then, so that you're ready to go forward on that day. Also, before you leave today, you're going to meet with Ms. Davis to set up a time for a pre-sentence interview. Okay.
yes.
All right, Mr. Trush, anything further today?
No.
Ms. Bruker?
No, Your Honor.
Thank you, Mr. LaRock. That's all.
Thank you. Have a good day.
Were you ready on Mr. Barshaw's case, Mr. Trush?
Yeah, sure.
Barshaw, if you'd like to come forward to the podium, please. Court calls People versus Andrew Barshaw. This is file number 256830. The record should reflect that Mr. Barshaw is present here in the courtroom today. This is the date and time set for a sentencing hearing. If I could have both counsel put your appearance.
Amber Brooker, appearing on behalf of the people.
Thank you, Your Honor. On behalf of Mr. Barshaw.
Mr. Barshaw, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yeah.
Did you need more time to do that before we go forward today?
No, sir.
Okay. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Bruker, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Just briefly, Your Honor, NDOC is recommending 10 to 23 months in count one and 2 to 17 months for count two. On the facts leading to this case where the defendant was being surveilled by SANE at the time of his arrest, he had around 15 grams of methamphetamine, 19 Ritalin pills, 3 syringes of methamphetamine, and Suboxone in his possession. He had 11 active warrants, had a police scanner in his possession in an attempt to circumvent his arrest on these warrants. His prior criminal history, including some of the active warrants he had out for filing information about methamphetamine. He's had controlled substance charges dating back to 2007. He served jail sentences before. He's been placed on probation before, and frankly, he's not benefited from either of those. So I would ask the court to consider for count one to issue an NDOC sentence. And that's really all I have, Judge.
Mr. Trush?
Your Honor, in terms of the prosecutor's recommended here, I don't think that's the appropriate response here. The court may recall, Your Honor presided over the matter in Crawford County. The court may recall approximately a year ago, he was sentenced on the probation violation in Crawford County that stemmed from these charges. We stood before Your Honor at that time, and Mr. Barshaw told you, right? I need to make changes, right? And he's going to talk more about what happened in his life, but he had some life changes that were happening then. And he asked you to allow him to go into treatment and said, look, I need to make changes in my life. I'm done with this. I am ready to be done. I'm ready to make changes. At that time, Your Honor sentenced him to 9 months in the county jail. He had some credit. He had served the remainder of that time. Since that time, what Mr. Barshaw has done, I think, is show the court that he was serious about what he said then. Since that time, he has not had any additional charges or interactions with law enforcement. He's complied with the conditions of his pretrial release, and he's done the things that he's supposed to do. Again, since that time, he's made the changes that he told you a year ago he was ready to make and was going to make. I would suggest to the court and ask the court to consider his prior history is relatively small. Again, prior record includes 1 prior felony, 4 prior misdemeanors. It's relatively small. I would suggest to the court that an appropriate response here is to give him an opportunity to show the court that he is serious. I think he has shown in the last year since this started that he's serious about making changes. I would ask the court to craft a sentence that allows him to continue that. The court could impose a county jail sentence and make him eligible for work camp. That would ensure that he's being tested. And it would also ensure that he's able to maintain employment and be a productive member of the community. And quite frankly, I mean, his testing requirements through the work camp are more significant than they would be in any other setting. And certainly more than it's going to be in MDOC. And, you know, we say MDOC is for sobriety, but I think we all know that there are drugs in MDOC. Even if he were on probation here or on parole after that, his testing requirements through the work camp are going to be more significant than they would be in any of those circumstances. And frankly, I think that is good for Mr. Barshaw. The accountability there would be good for him. Prior to this circumstance, he had a child and realized he needed to make changes in his life. And he's done that. Again, since this incident, there's nothing to suggest that he has not done what he's supposed to, which I think shows he's a good candidate for supervision. And I think it would be a more appropriate sentence to have him in the county jail than an MDOC. If the court were inclined to do MDOC, I would ask the court to consider the boot camp program. Thank you.
All right, thank you, Mr. Barshaw. Anything you wanted to say?
I couldn't have put too much into better words than he could. Sorry, I lost my voice. I have a 1-year-old son at home. And when I did stand before you and tell you I need to make changes, I had just learned that he was mine. I just met him actually through visitation at the jail, as sad as that is. But since then, when I said I want to change, I meant it. This time I went through all the testing, everything that you guys sent me. Does my bond release conditions, and started a business. I've got a family. I talked with my mom again. I actually forgot a 9-month recovery coin that I was absolutely just willing to walk through the metal detector with this morning, just to show you. I worked hard for that coin. And I got my son and his 2 brothers at home. They're not mine yet, adopted wise. But everything in my life has changed. I need the whole entire old chapter just gone. And work forward on that. I'm asking to let me just work forward on that.
All right. I did read through the report, so I'm familiar with what happened in this particular case. As Mr. Trush indicated, you know, I was already familiar with you and your circumstances generally from Crawford County case. But I also read through that portion of this report as well, in terms of any updates from the last time you reported in Crawford County. And, you know, there's a really wide range of options that the court has in this case because of the circumstances. One of the charges has an upward or top end guidelines of 23 months, so almost up to 2 years in prison. Because of the circumstances here, the court has the discretion to sentence consecutive. So if the court were to go to the top of the guidelines on both charges, you're looking at, you know, over 3 years in prison. Bottom end, of course, is basically 2 months in the county jail. So there's a huge range here of potential sentences. So I say that because, number one, I want you to understand that you could be looking at a really lengthy prison sentence as a result of this. And you need to understand that that's where you're at in terms of your criminal history and where you're going to be if you don't get a hold of this and if you continue to reoffend. The next court that sees you is likely not going to have that lower end option anymore. And it's going to be prison time, no question. Do not pass go, you're going right to prison. With a young child and somebody in your circumstances, I don't think that's what you want to have happen. So I'm saying all of that because I want you to understand that this is really your absolute last opportunity to avoid that. And really, it could happen here in this case. So that's how close you are to that as your future in the short term. The circumstances here, 15 grams of methamphetamine is not a small amount of methamphetamine. The fact that you were absconding, evading law enforcement, all of those are aggravating factors, which would make, I think, the court more than justified in sentencing you to prison on this charge. This charge is here today. I also, though, have to recognize the mitigating factors, not just the aggravating factors. And those have been pointed out by Mr. Trush, I think, very well. In this case, what I think is an appropriate sentence is somewhere in the middle of that, because I think those things balance themselves out. I don't think, you know, at this point in your criminal history, you've had a couple jail sentences, you've had a couple chances on probation, but certainly not, I think, to the point where prison is absolutely the only option. Again, I think after this, that's probably where you're at. So balancing all the factors, the court finds that a jail sanction is an appropriate sanction, a sanction within the middle of the guidelines. And this is generally within the middle of the guidelines as to both charges. This is a nonviolent offense, so I think work camp is appropriate if you're eligible for that. So I find that an appropriate sentence in this case would be, as to both counts, would be 12 months in the Otsego County Jail. You have credit for 3 days served. The court, again, has no objection to your participation in the work camp program if you're eligible. Court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and $136 state costs. You do have the ability to seek an appeal of this sentence. Mr. Trush is going to provide you with an acknowledgement of your appellate rights. Those papers will explain to you how to request an appeal as well as how to ask for a court-appointed lawyer to help you with that. Sorry, are remanded to the custody of the county at this time.
You know,